All right, now that we have all of our panelists, I think we'll get started. This is the last panel of the day, and the topic is state, non-state, and quasi-state interference with reproductive autonomy. We're going to be having 4 panelists, and then we'll hopefully have about 20 to 25 minutes for questions at the end. Our first speaker is Martha Davis. She's a professor of law and the associate dean for clinical and experiential education at the Northeastern University School of Law. Professor Davis has written on women's rights, poverty, and human rights, and her career has included women's rights litigation at the U.S. Supreme Court and positions at the Albany Law School and Harvard Law School. She currently chairs the board of directors at the National Economic and Social Rights Initiative and serves on the editorial board of the Harvard School of Public Health's publication, Health and Human Rights. We also have Jessie Hill, who is an associate professor of law at Case Western. Professor Hill focuses on reproductive rights, law and religion, as well as healthcare rights. She has practiced civil rights law in private practice, and she's worked at the Reproductive Freedom Project, which is part of the ACLU. She has litigated challenges to state law restrictions on reproductive rights. We also have Erika George, who is a professor of law at the S.J. Quinney College of Law at the University of Utah. Her research interests include women's rights, human rights, cultural pluralism, and rights universalism, as well as gender violence and gender equality. She has practiced corporate litigation and served as a fellow with Human Rights Watch, as well as conducting human rights investigations in South Africa. She serves as special counsel to the Women's Rights Division of Human Rights Watch, and she has served in other non-governmental and advocacy groups. And lastly, we have Rebecca Schleifer, who is in the Women's Rights Division of the Human Rights Watch. Her research and advocacy at Human Rights Watch has focused on the role of criminal law in addressing the response to HIV and AIDS, including governmental restrictions on HIV/AIDS information to youth, and to HIV and harm reduction services to injection drug users and prisoners. She has also focused on HIV prevention and other post-rape services to survivors of sexual violence and abuses against people living with or at risk for HIV/AIDS in the US, Jamaica, and other countries. Before Human Rights Watch, Ms. Schleifer has worked with migrant farm workers in the US, litigating cases on wages and working conditions and conducting advocacy issues regarding pesticides. So I'll let them take the floor, and hopefully we'll have around 20 minutes for questions.
Thank you, Valerie. Thanks, as others have done, to the organizers. And we were just saying up here that this has been one of the most enjoyable of these kinds of symposia that we've been to. It's very lively and interesting. So thanks to all who contributed to that. So probably some of you have read or heard about this book, Nudge, Improving Decisions About Health, Wealth, and Happiness by Richard Thaler and Cass Sunstein. And I'm going to talk a little bit about the concepts in that book in the context that we're talking about today. The basic thesis is that there are small, non-coercive things that a government or another institution can do to promote better choices for health and wealth and happiness. So like the example they give at the outset is like putting vegetables at eye level in the school cafeteria, or giving, the one example that I could find in the book about reproductive choices was giving at-risk teens $1 a day so that they don't get pregnant. So a city would have a program of doing that. To qualify as a nudge under their framework, the intervention must be one that can be avoided easily at low cost to the nudgee so that free choice remains. And in the book, they list hundreds of nudges, many of which arise because the government has positively occupied the space and has to make a decision of one kind or another. So the vegetables in the cafeteria have to go somewhere. Why not put them where they'll do the most good, at eye level? or the state has resources that it has to allocate, scarce resources. How should it allocate them? Why not allocate them in a way that's going to maximize good choices? So it struck me in looking at this book that we don't have a very strong account of what constitutes an acceptable nudge in the area of reproductive choice and what crosses the line into an impermissible government influence of fundamental personal decisions. And for example, Thaler and Sunstein breezily mentioned this $1 a day example. Certainly wouldn't coerce them to get $1 a day to not get pregnant, but they don't even contemplate that it might be unduly coercive to low-income teens. Can these teens really walk away at low cost or no cost from the $1 a day for not getting pregnant? And you can't answer that by simply saying, well, it's an empirical inquiry whether or not the policy is unduly coercive or too interventionist, because if it doesn't work, then it's not a nudge. If it does work, then it is a nudge, but is it working so well that in fact it's coercive? It's very hard to say empirically at what point it becomes a coercion as opposed to a successful nudge. So today I'm going to talk about this notion of an innocuous nudge from government in the context of governmental policies to influence family size. And in the US, I focus on the family cap, which I had experience with as a litigator. It's been adopted by 23 states as part of their welfare programs. And I'll describe the domestic approach and then put the policy in a comparative perspective and draw some tentative conclusions about where on the spectrum the US approach stands internationally. And interestingly, US courts considering these programs typically see them as mere nudges. And that's true internationally as well. And I'm interested in thinking about the factors that might make these initiatives impermissibly coercive, might take them too far. Now, government efforts to either encourage or discourage procreation are not unusual. And just a few days ago, BBC reported this, the South Korean Ministry of Health had started a new lights out policy. So according to the BBC, at 7 p.m. on this past Wednesday, officials at the South Korean Ministry of Health turned off all the lights in the building, encouraged the staff to go home to their families and procreate. And they plan to repeat this experiment every month. South Korea apparently has one of the world's lowest birth rates, and the Ministry of Health wants to have a model, be leaders in encouraging the South Korean population to populate their country. So that intervention seems like a true nudge, right? It's no cost to the employees to avoid the intervention. I mean, they don't go home, or they do go home and they watch TV instead, so it seems easy for them to avoid coercion in that situation. Another example of a situation where maybe coercion wouldn't be of concern would be these sorts of contests that governments sometimes run. An example is in the welfare 1996 law, where there was a out-of-wedlock birth rate reduction contest among states, and states that did the best could reap rewards from the federal government. Well, the policies that the states adopted might be coercive, but the concept itself didn't imply a coercion. Instead, was a kind of encouragement to states to prioritize these kinds of initiatives. The family cap in the US, in contrast, is significantly more intrusive, but it's not Skinner, it's not mandatory sterilization, and so the question is, where do we come down on things that are not mandatory sterilization but are more intrusive than a lights out policy? So what do I mean by the family cap? So this is a little bit of welfare 101. Since 1935, the federal government has provided matching funds to states so that they can provide subsistence-level benefits to low-income families. And since 1996, when the welfare reform law kicked in, the program has been called TANF, Temporary Assistance to Needy Families. And under TANF and its predecessor program, the federal government provides a template to states for various policies, but gives states considerable latitude to distribute welfare benefits and to set benefit levels. Over the decades, most states distributed benefits based on family size. Larger families would get incrementally higher benefits. What we're talking about is all relative. These benefits were typically just a fraction of the poverty line, and they certainly didn't raise recipients' incomes above the poverty level. But they would get a little bit more as family size increased. But as early as 1970, states were experimenting with limiting these subsistence benefits as a way to discourage childbirth in low-income families. So in Maryland, for example, the state capped benefits at $250 a month, regardless of family size. As a rationale, Maryland stated, among other things, the policy provided incentives for family planning by welfare recipients. And this policy was upheld by the U.S. Supreme Court in a case called Dandridge versus Williams. Even Justice Thurgood Marshall, who dissented from the court's ruling on other grounds, found that the family planning intent that the state had put forward was not of concern. According to Marshall, quote, "The effect of the maximum grant regulation upon the right of procreation is marginal and indirect at best, totally unlike the compulsory sterilization law that was issued in Skinner." So it's not Skinner, therefore it's merely a nudge. We don't have to worry about it. 20 years later, states in the 1990s again began experimenting with ways to use welfare benefits to deter childbirth by recipients. And this new iteration of the family cap that was pioneered by Wisconsin and New Jersey denied an incremental benefit increase when children were born to women while on welfare. So in that scenario, one family of 4 might receive a different amount than another depending on when the child in the family or the children in the family were born, whether the mother was receiving welfare benefits when the children were born or not. And during the welfare reform debate, there were some sectors that argue the states should adopt this policy as a mandatory condition of getting their federal welfare funds. Early drafts of the law had a mandatory family cap, but the federal legislation ultimately made the policy an option, and as of today, 23 states have adopted this version or similar version of the family cap. There have been a number of legal challenges to family cap policies in the states that adopted this approach. And most notably, the policy was challenged in New Jersey, both in federal court and state court. Those are the cases that I was involved in. And those challenges included claims based on the violations of the right to reproductive choice framed both under federal and state law. Both the Third Circuit Court of Appeals and New Jersey Supreme Court rejected the claims. They found that any impact on reproductive choice was far too minimal. In fact, the Third Circuit said it would be remarkable for us to find that this violated reproductive choice. It was far too minimal an impact to sustain a claim. Nationally, legal challenges to the family cap had some success around the margins, but no court upheld a challenge on the ground that the cap intentionally and permissively interfered with low-income women's reproductive choices by denying them benefits if they gave birth while on welfare. So the main points I want to make about the U.S.-based family cap is that it was intended as a disincentive to childbirth that denies benefits rather than rewarding approved choices, so in that sense it's different than the $1 a day. And you can contrast it in the U.S. Context to tax policy, which at least provides a mix of incentives and disincentives. And then second, that the family cap is not universal, nor is it connected to some national population policy that applies to all. It affects, by definition, only low-income people, only welfare recipient families, and these families are disproportionately people of color. So now I want to take a look at some comparative laws and policies, and probably the most well-known example of a contemporary government effort to deter childbirth is China. So in China, families that have more than one child are required to pay a very hefty fine, up to a year's salary, maybe more. The policy is essentially universal. There's some, some isolated exceptions, but essentially universal. Earlier in the iteration of the policy, forced sterilization and forced abortion seem to have been somewhat common. But now the evidence is that they're uncommon and certainly not part of official government policy. So China's policy has been the source of litigation in the U.S. As a basis for political asylum, likewise in Canada. And while the idea of forced sterilization and forced abortion have been cited as adequate grounds for asylum, and in fact now are in the asylum law as significant as permissible grounds, the official one-child policy itself hasn't been deemed sufficient by U.S. courts to support an asylum claim. And likewise with the Canadian courts. The one-child policy itself and the substantial fine that accompanies it are not sufficient to support asylum. Now let's turn to India, another nation that's been more aggressive in exercising government influence over procreative decision-making. And not surprisingly, maybe both China and India are countries that are responding to very high population pressures. So India has a national population policy, and implementing that policy, the Indian state of Haryana took an unusually aggressive measure, passed a law forbidding anyone with more than 2 living children from holding a local elective office. It's not something we would think about in the U.S., but the policy was challenged and considered by the Indian Supreme Court in a case called Javed versus Haryana in 2003. And the court examined this two-child policy in light of the nation's comprehensive population goals and concluded that there was no legal violation. Critical to the ruling was the fact that no particular social group had been targeted for denial of the opportunity to run for office. And in fact, as the government explained, the Haryana folks were actually looking for prominent role models to show the benefits of small families. So choosing elected politicians to model this behavior was was perfect for them. I mean, it's as if all US senators were required to limit their family size in order to hold office, to model behavior for the rest of us. So how do we feel about this policy? I mean, people laughed when I told you about it, so it does seem kind of foreign to our culture. It's universal in the sense that office seekers are not an identifiable class, but it's clearly coercive. If you really want to hold office, you don't have any other options. And you couldn't easily avoid this rule. The Supreme Court specifically said that you couldn't put your kids in foster care. That wouldn't allow, you couldn't put your kids in foster care and then run for office. You had to not have the kids. So that's India. Now, while the case law is sparse, there are many other nations that use positive government incentives and disincentives to influence childbearing decisions. So also in India, there's a national policy that provides financial rewards to poor people. So for example, couples below the poverty line who undergo sterilization before having a third child receive health insurance coverage for themselves and their children. So they're rewarded for sterilization. In Burma, in 2005, couples seeking permission to marry were required to sign an undertaking not to have more than 2 children. So there's a condition on marriage. At the other extreme is Mali, which focuses its efforts on education, at least in their written law. So the Mali law tracks the CEDAW language on family size and spacing of children and adopts, quote, necessary measures to facilitate access to information, education, and the means to exercise these choices, and also talks about respect for the basic rights of children and providing the means to ensure their survival. So we've got Mali on one end, and the other end, maybe the China example. And then where does the US family cap fit into this range? Well, like China and the Javed case from India, the family cap intervenes to punish rather than to reward. It's different from the Javed case in that by definition it withholds subsistent benefits, not electoral office, which isn't going to undermine your basic human needs. Like the policy in Javed, but unlike China, the family cap affects only a subset of the community. It's not universal. But the family cap classification seems more troubling since it's associated in the US with race and class. It's disproportionately people of color. In contrast, the Javed classification is based on those seeking elective office, is more likely to be fluid and cut across populations. Mali's focus on education is also in stark contrast to the US approach. Ironically, the US welfare reform law included funds restricted to absence only until marriage education rather than broader, more comprehensive educational approaches. So here you have a policy that's punishing folks who have additional children while at the same time restricting availability of educational materials that might give people information that would help them make choices. So in sum, the family cap as implemented in the 23 US states combines many of the most objectionable features of the world government's efforts to intervene in procreative decisions. It punishes a small subset of the population using important subsistence benefits while providing incomplete sex education to the affected class. There's several scholars in the US, and at least one amicus brief, have argued that the US family cap violates international human rights law. But one of the problems that we faced in drawing the line between what's permissible and what's not, is drawing the line between what's permissible and what's not. And perhaps this is in part because of deference to policymakers. Courts tend to find everything short of Skinner to be a nudge because it would require second-guessing population policy that legislatures have put forward otherwise. This comparative look, though, I think bolsters the claim that the US is an international outlier. The family cap, I would argue, goes over the line from a nudge to impermissible coercion, wherever that line is, by focusing on a vulnerable population and denying benefits rather than rewarding certain behavior. And the US is an international outlier in this regard. So, thank you.
Thanks. I also want to thank the Law Review for putting together this symposium and inviting me to participate. It's been a really wonderful way to spend a day for me. For my contribution to this panel, what I want to talk about is the meaning and role of the concept of health in American reproductive rights jurisprudence, specifically in the context of cases that deal with state-imposed abortion restrictions. I'm going to just admit that it's only sort of tangentially related to the title of this panel, but it's too late now for anyone to do anything about that, I suppose. Okay, just see whether you're awake, I guess, enough to catch that. Okay, so health is, in my view, extremely important in reproductive rights law. Certainly health, and particularly the health exception, in other words, a requirement that an abortion restriction has to have an exception allowing the abortion to go forward where it's necessary for the woman's health. That's the health exception. It has been at the center of an enormous amount of abortion litigation in the past decade or so. But the concept of health within that jurisprudence is notoriously poorly defined. So what I want to do here is discuss briefly how the concept is defined, if at all, by the abortion case law. And then to think about the implications about what this might say about the problems and possibilities of defining health within broader legal discourses that attempt to situate reproductive rights within the umbrella of the right to health. Whether we're talking about the international human rights domain, where that connection is perhaps more well established, at least in theory, though as far as I can tell, it's only sort of started to get real legal teeth recently. Or also even in the US, where some advocates like Cynthia Suhu and scholars are trying to talk about a meaningful right to health that might include a right to access reproductive health care. And I also hope that at least that these reflections might have some just general relevance given the sort of salience of debates about health and healthcare reform right now, especially to the extent that there might be a greater public role in health coverage decisions and so on, possibly in the future. Having a working legal definition of health seems helpful. So what do we know about how our reproductive rights case law has defined health? Well, as I sort of just suggested, and as actually Professor Siegel talked about as well, the concept permeates the Supreme Court's abortion cases, but particularly the early cases like Roe v. Wade and Doe v. Bolton. But it carries through Stenberg and Carhart, Stenberg v. Carhart and Gonzalez v. Carhart, while again remaining kind of not very well defined. The early cases, Doe and Roe, view abortion, at least in part, as a medical decision that should be treated like other medical decisions. And indeed, those opinions have been criticized by feminist scholars for the extent to which they treat abortion as a matter of medical judgment, to be placed in the hands of the physician, even to the exclusion of the agency and judgment of the woman herself. Thus, the court in Roe, for example, claimed to vindicate the right of the physician to administer medical treatment according to his professional judgment, up to the points where important state interests provide compelling justifications for intervention. Until the point of viability, when the state's interest in the fetus becomes compelling, the court explained, the abortion decision in all its aspects is inherently and primarily a medical decision, and basic responsibility for it must rest with the physician. Similarly, in Doe v. Bolton, the companion case to Roe, the court compared the abortion procedure to other surgical procedures, noting that the Georgia statute at issue in that case regulated abortion in ways that were unimaginable for other surgeries, and underlined again the importance of the physician's medical judgment in determining the appropriateness of abortion in an individual case. And then proceeded to define that medical judgment very broadly to take into account not just the women's health concerns, physical sort of, not limiting it to a concept of health, but a sort of general holistic well-being kind of concept that went into medical judgment that included physical, emotional, psychological, and familial factors, as well as the woman's age, according to the court. And then, of course, so there's this sort of general, broad, holistic framework of sort of medical judgment as involving overall well-being of the patient. And then there's the other aspect of Roe, which was its holding that Roe's explicit holding that after viability, even once the state's interest in the fetus has become compelling, that the state's interest still must give way when the woman's life or health is at risk. And this is where I think it gets a little complicated for a couple of reasons. First, because the court never really explains why. I mean, never really explains what grounds the health exception, why under this 14th Amendment concept of privacy, under a woman's right to make an autonomous decision about whether to continue an unwanted pregnancy, how does that explain this post-viability health exception? That's something that never really gets analyzed. And I personally have argued elsewhere that this post-viability health exception requirement might be grounded precisely in a sort of negative right to health. But that's not the focus of what I want to talk about here. And second, this post-viability health exception complicates matters because it seems like here the court is talking about or means something different when it says health. In this context, health seems to refer to freedom from harm, particularly significant harm. Whether physical or otherwise, whether that's limited to physical harm or not is again unclear. But this concept of health seems to have an affiliation to sort of a concept of self-defense, of necessity. It evokes this elective therapeutic distinction, which again can be contrasted with the more general rhetoric of abortion as healthcare, which sees health more holistically as a state of overall well-being and sort of the object of autonomous decision-making about how best to take care of one's body. So I'm just sort of suggesting that the meaning of health can be different in these different contexts. This broader definition of health in Doe makes us maybe think of the World Health Organization's definition of health discussed during the early panel as a state of complete physical, mental, and social well-being and not merely the absence of disease or infirmity. There are other cases that do touch on the definition of health, but I kind of want to skip ahead to the Stenberg v. Carhart and Gonzalez v. Carhart, which are perhaps, of course, most significant discussions of health in the abortion context. Both Stenberg and Gonzalez, of course, are cases in which the Supreme Court considered bans on a procedure known as partial birth abortion, known popularly as partial birth abortion, and in particular decided, in part, whether the laws banning that procedure were unconstitutional because they lacked a health exception, which would allow the procedure to be performed when it was safer for the woman than other available procedures. Now, Stenberg and Gonzalez did not deal with the question of when an abortion is or is not permissible, as in the post-viability health exception context, but rather with the question whether, if the abortion is a legally permissible one and will go forward in any case, whether the woman can constitutionally be forced by the state to have that abortion by means of a procedure that her doctor believes is riskier for her than another available procedure. When the court held in Stenberg that the ban was in fact unconstitutional without a health exception, it seems to me that it was in part recognizing again this right to protect oneself, a sort of medical self-defense right, or a concept of health as freedom from harm. Interestingly, the court seemed to hold on to this same concept of health as well as the same sort of recognition of a right to health, in a sense, in Gonzalez v. Carhart, even though it came out in the later case, Gonzalez, even though it came out the other way and upheld the federal partial birth abortion ban that lacked a health exception. The later Gonzalez case neither took issue with the notion that women have a right to avoid harm to their health that may be brought about by state regulation of abortion, nor with the notion that this particular regulation, this particular ban may in some circumstances impose significant health risks on a particular woman. Well, it didn't dismiss either of those propositions out of hand. Rather, the Supreme Court turned away the challenge, it said, because it felt that in light of the allegedly conflicting medical evidence in front of it, the existence, well known, of those risks should be considered in the context of an as-applied challenge rather than the facial challenge that the plaintiffs have brought. So presumably the as-applied challenge that would bring specific types of health conditions before the court, although not necessarily particular women, but presumably it would bring particular health conditions before the court to be evaluated on an individual basis. So were both the Stenberg and Gonzalez cases working with the same concept of health? Well, yes and no. I mean, it seems, as I said, both seem to view health as being about preventing harm, to the woman. Again, some sort of maybe non-negligible risk of harm, unclear whether we're just talking about physical harm or other kinds of harm. But where they really do differ is in terms of who is entitled to determine how best to avoid harm to the woman's health. And here I think I'm going to start invoking a little bit some of the concerns that Professor Coan talked about in his discussion of sort of institutions and institutional competence and where they play into this question. It seemed to me, so the Stenberg court's attitude was, once we've determined the possibility of health risks, that means we have to leave it up to the woman and her doctor to decide when the procedure is medically necessary and appropriate. It might remind us somewhat of the Roe and Doe framework even. The Gonzalez court was a bit more skeptical of that idea, to say the least. It seemed to see a substantial role for the legislature in defining what procedures may and may not be medically necessary. It was also unwilling to adopt an across-the-board health exception that would essentially delegate these sorts of decisions about medical necessity in the narrow sense to the physician. Instead, the Gonzalez court saw a continuing need for involvement by the government, and particularly probably by courts, which would be charged with further specifying when the procedure was or was not necessary to protect a woman's health. Okay, so now that I've kind of briefly sketched out, I can't even really call them definitions, but ways in which the court kind of talks about health in its abortion jurisprudence. I'd like to spin out these concepts a little bit and make sort of some observations about them to show how they pose challenges for defining health in the context of a right to health that may more broadly encompass reproductive health. The first observation, of course, is that it's a negative right, and that also has been talked about a bit today. A right to, at least within U.S. abortion jurisprudence, the right to health is conceived of as a right, to the extent that there's a right to health, it's a right to freedom from interference by the government with healthcare choices. Whether that's defined as a general right to privacy in the physician-patient relationship or a narrower right to avoid state-imposed harm to one's physical or mental well-being. And so, you know, personally, I believe, and like I said, I've argued elsewhere, that this negative right is a powerful one that potentially, if sufficiently robust, could protect women from a variety of state interventions aimed at denying them their rights. At the same time, though, of course, this negative conception of a right is somewhat in tension with the international human rights goal of enforcing a positive conception of the right to health, one that would include state obligations to provide individuals what they need to achieve an overall state of well-being. In addition, there are, of course, broader and narrower concepts of health that I've just outlined here. The broader one includes a more holistic concept of well-being and bodily autonomy, and the narrower is focused more on protection from harm, however that harm may be defined. Physical or mental, substantial, non-negligible, it's a little unclear, but and this too may seem a bit obvious, but I do think it's important to point out that the broader right is not necessarily correlated with the positive conception of the right and the narrower with the negative conception. So even though it might be sort of associated in practice that way, the broader view is kind of more associated with the International Human Rights Agenda, the WHO definition, and so on. It's possible to conceive of a broad but negative right to health, a right against government interference in all of the various ways in which individuals choose to seek beneficial medical intervention to care for their bodies, without limiting it to a strict concept of medical necessity or self-defense. And also, I guess you could have a narrow but positive entitlement to protect your health, like one might think of EMTALA or these, entitlements to emergency care or something along those lines. Also lurking, though, within the concept of health, as I've just alluded to in my discussion of Stenberg and Gonzalez, is the issue of who gets to decide what health is and when a procedure is medically necessary or indicated. So it seems to me that this is sort of a concern that situates itself within how we understand health itself. I mean, it seems inseparable to me from the problem of defining health. And as I just noted, the Supreme Court has often implied, especially in its early cases, and arguably Stenberg, that it's the doctor, it's the individual physician who should make this decision. And I've even suggested in another article that that maybe there's a reason why the health exception has been left so completely undefined in our jurisprudence, and that's because it sort of, by wording it as a general exception that leaves the meaning of health to medical judgment, it's precisely an intent to delegate this decision to individual physicians. At the same time, though, it's important to recognize that, you know, there are a lot of health decisions that we have traditionally delegated to legislatures, things about, you know, access to drugs, mandatory vaccination, things like that. And we tend to think that legislatures do have some role to play in deciding on a broad scale, at least, what's medically appropriate. So it is a little bit in tension with this notion. But I think, you know, both of these alternatives are sort of problematic. I mean, it's problematic to give legislatures a big role to play in defining health and medical necessity, in part because I don't think they're very competent to do so. And nor are courts particularly. I mean, I think courts may be more competent, but they're also not particularly competent to make these sorts of determinations, like of the sort that Gonzalez and Stenberg call for. When is a particular procedure necessary? But also because health, it's fundamentally a kind of highly individualistic determination, right? Which depends both on the skills and views of the individual physician and the particular history, physical characteristics, and values of the individual patient. I mean, to sort of illustrate this, you know, when I asked some folks what, who are a little more in the know, what physicians were doing after the Gonzalez v. Carhart opinion, which decided that they could no longer use this particular procedure when they felt it was the safest, you know, they said there's no answer. There's a wide variety. Everybody has a different comfort level, right, with what they feel is the next safest option. I mean, they weren't doing that procedure anymore, but there are a variety of ways of responding and ways of working around it. That's, again, partly why the health exception is so, had been perhaps for so long delegated to the individual physician. But then at the same time, this is problematic too, right? To say that decisions about health should be left to expert physicians seems to certainly leave the patient out of the equation, right? And it also invokes these concerns about ways in which historically medical discourse has operated hegemonically as a form of social control, and particularly as a means of subjugating women and controlling their bodies. To delegate decisions about health to healthcare professionals, although it may be preferable to delegating it to courts or legislatures, is not entirely satisfying from a women's rights perspective. So where does this leave us? I'm not quite sure, but to sum up, I think the challenge is to come up with a concept of health that is probably broad, compatible with a positive rights framework, and to address this last set of concerns, somehow individualized and patient-centered. A concept of health and autonomy within healthcare that goes beyond mere informed consent to take individual women's bodies, values, and agencies into account. So that's what I would like to suggest as part of the sort of agenda going forward in terms of defining a right to health, that it could include a right to reproductive health care. Thanks.
Hi, good afternoon. I want to add my congratulations and thank you to the chorus of people who've preceded me, to the Case Law School, and particularly to the editors of the Law Review. We've had a wonderful stay and a wonderful conference. And to thank the audience for staying until the end and for being present and your active participation previously. My remarks are going to take a bit of a departure. We've heard so far about state nudges or state interventions. I'm going to talk about non-state influences that impact on women's decisions in the reproductive rights sphere. So in this room, probably a number of you are survivors of sexual violence. Or you may know someone who is, but what's more likely is you probably know someone and don't know that you do, because violence is so often shrouded in silence. And that's something that's kind of common to conversations about abortion, subjects that just aren't shared, that aren't spoken about. And these two topics are not often brought together in conversation. So my remarks today are going to do that. I'm going to spend time talking about how violence perpetrated by non-state actors, sharply constrain the range of reproductive rights available to women, impact, influence their reproductive health, and then I'll turn to maybe what the role of the state could and should be, or rather state omissions that allow these kinds of violations to perpetuate and to occur globally. So there are three parts to my talk. I'm first going to talk about violence and the different types of violence. I'm categorizing them into three: violence that are relevant to reproductive choice issues. The first is going to be individual or interpersonal violence. The second is something that I will call systemic, structural violence. And then the last I will call political violence. I'll be speaking in turn about violence against women, indignities in medical services, forced sterilizations that I will call systemic or structural forms of violence. And then I'll talk about violence against abortion providers as political violence that sharply curtail the availability of access to abortion, though these remarks are broader than simply the question of abortion. Then I'll turn to how violence violates rights as we understand them, not just reproductive rights, but violence certainly has implications for all ranges of women's human rights. And then finally, I'll turn to potentially considering how at the intersection of reproductive issues and anti-violence activism, we may find some additional space for engaging a conversation with maybe people who don't share our worldview, but we can come to some kind of consensus around the harms of violence against women and implications for state intervention in different systems that I think contribute to violence and constraining freedom of choice. So, rape. In the United States, between 1 and 5 or 1 in 7 women have survived a rape. And around the world, there's a real consistency of demographic across countries in terms of sexual assault. The majority of assailants are known to victims. A high percentage of assaults are against younger women and girls. Well, younger women, I should say girls, children, 15-year-olds and under. Between 7 to 48% of adolescent girls and between 0.2 to 32% of adolescent boys have reported that their first sexual experience was forced. Violence against pregnant women actually is a significant problem. While pregnancy, according to human rights statutes, treaties should be a special time of consideration of a woman's health and well-being, and they're specially protected, surveys suggest that women who are pregnant are prime targets for abuse, and oftentimes even in relationships that hadn't previously been abusive, abuse can start when a woman is pregnant. And women who are pregnant and abused run twice the risk of miscarriage, 4 times the risk of low-weight birth babies, and these are significant predictors for child survival in their first year of life. This has a greater impact on women in the developing world, violence in pregnancy, but again, in the majority of cases, the perpetrator is often the father of the child. Violence is more common, even in the United States, than hypertension and preeclampsia in prenatal care when providers inquire in ways that would draw out these issues. Between 1 and 28% of women reported physical abuse during pregnancy by an intimate partner. The numbers I'm getting are coming from a WHO report that was done in 2002, a 10-country survey of over 24,000 women to get some sense of violence, frankly, as a public health issue, an international public health crisis. Conflict regions are severe place of insecurity for women. Sexual violence is rampant and often used as a device in war and conflict in Bosnia and Rwanda and currently in Eastern Congo. And at the same time, there are 2.5 million women being trafficked anywhere in the world with, again, implications for sexual violence. Most relevant to influencing choice is intimate partner violence. It's widespread, happens in both developed and developing countries. Prevalence can vary widely between countries and between regions and within different groups of women. But again, this WHO multi-country study found that between 13 to 61% of women, 61% of women who had been married reported physical abuse, and between 6 to 59% of them reported rape or sexual abuse in addition to the physical abuse in the context of their relationship. So violence is commonly accompanied by emotional abuse, economic restrictions, and other kinds of controlling behavior that, again, restrain and constrict the kinds of choices that women are able and free to make, without the state having much role in any of these influences. And again, the violence is mostly in silence, particularly the intimate partner violence, more so than other forms. And women often don't seek help, certainly not from police. If anywhere, they're more likely to seek counsel from their healthcare provider. So again, greater conversations about sexual violence in the context of prenatal care would be a valuable thing. So that's the individual violence that is a factor. Turning to the medical system violence, there's been a sad history of forced sterilization within the United States and outside of it, sometimes linking welfare benefits to submitting to surgical implantations of Norplant is implicated, and just general humiliation that women may face in seeking health services, particularly in populations of women of color or in other countries, members of disfavored minority groups when engaging with a healthcare system has faced discrimination and not received adequate services. So I'm just taking a broader conceptualization of what violence entails, principally rooted in coercion, whether that's physical or not. In the United States in particular, violence against providers is another way that women have, let's say, fewer choices. Most recently, George Tiller, an abortion provider in Kansas, was shot and killed in his church. This was not before his clinic had been bombed. He had previously been shot and had persistent, constant protesters in his house and in his clinic, or at his house and in his clinic. That was in 2009. In 1993, David Gunn, another abortion provider, was shot and killed. This was at the entry of the Clinton administration. There's new research or new learning to show that upticks in violence against clinics, providers happen when those opposed to abortion perceive losses of power. More extreme elements emerge, escalating anti-abortion rhetoric and directing and instigating violence. Under the Bush administration, in the years between 2000 to 2008, there were no more murders of providers, whereas in the Clinton administration, there were 6 murders of providers, 17 attempts, 12 bombings, but actual abortions were up under the Bush administration. This violence, I think, is a very clearly political kind of violence, expressive, intended to signal and to send a message when there's a perceived power shift and perhaps a lack of voice perceived in the community that opposes abortion. So Obama, in his speech to Notre Dame, said that violence isn't really how we're going to resolve this issue. But at the same time, I think there needs to be a more honest conversation about the sources of the violence, what it intends, and the impact that it has not only on the doctors who are murdered, but those who would plan to go to medical school, learn this procedure, or provide it to women. So it certainly has a chilling effect, again, non-state, but effective. So systemic violence, interpersonal violence, political violence, all shaping the space of, or constraining the space of choice for women seeking access to reproductive services. The consequences and causes and the role of violence. Gender violence is rooted in gender inequality, and it's simultaneously gender inequality is a consequence and cause of violence. Violence contributes to women's ill health by especially reducing their sexual autonomy. I mean, there's just nothing more can be said about rape as truly denying any choice in who it is where a woman would choose to have sexual relations with. So it kind of renders meaningless this conversation about sexual autonomy or equality as grounding a right to interpersonal intimacy, virtually eviscerating, even in the most progressive countries where you would have a full plethora of sexual autonomy, it's by veto, fiat, and independent of law that this disenfranchisement occurs. Violence contributes to multiple rights violations. I actually began my violence work looking at how violence impacts the right to education, how violence impacts a variety or range of other things. So it's a kind of multi-sectoral rights violation, and remedies to solve it need to reach beyond the state. violence can lead to unwanted pregnancies. So this is, again, something that is a challenge. So not only is violence a bodily integrity injury, a harm, it can lead to unwanted pregnancies that can in turn lead to unsafe abortions, and again, more injury, infection, and potentially death for women. In countries where abortion is illegal, women carry a rapist's child, or they can't control or negotiate condom or contraceptive use based, again, on culture. And the lasting chronic conditions such as pelvic pain, anxiety, depression remain untreated if you aren't grounding reproductive health in a concept of rights. Violence also impacts power relationships. So women who are dependent upon men economically or in interpersonal relationships that they can't leave may fear male reprisal. There have been studies done in developing countries that suggest that a lot of unwanted pregnancies come from women who haven't been able to successfully negotiate contraceptive use. Contraceptive use or requests for contraceptive use are perceived as a challenge to male virility or authority or an indication of female infidelity. So women will choose not to have this conversation, or the conversation gets cut off or circumvented again by violence. So I would suggest that animating a lot of what women choose to do and not do is kind of this unspoken but existent fear of violence that is perpetual in the lives of many women. I've mentioned earlier that a lot of violence occurs when women are younger in their life. This kind of violence has a lasting legacy that again impacts relationship health and reproductive health. So the relationship between childhood sexual abuse or sexual assault and high-risk sexual behavior later as an adult is direct. Teen pregnancies, increased incidences of sexually transmitted diseases, again, can be put at the foot of violence against girl children. Self-worth, self-esteem, the other kinds of things that are intangible and unmeasured in our legal conversations about rights, again, remain underexplored, but women or young girls are more likely to disassociate from their body and not perceive themselves to have self-worth, and then later not exercise their interest in other rights that they should be able to enjoy. So at the root of the violence is really kind of this terroristic threat that constrains and controls what it is girls who later become women feel that they are entitled to and what they're able to do. And again, the WHO studies have increasingly been showing multiple negative effects on women's later life sexual and reproductive capacities. You can be severely injured. On a global scale, the results from the 50 population-based studies worldwide are now showing that between 10 to 67% of women report being physically harmed by a male partner at some point in their life. This is not even beginning to get to the mental or emotional problems. So this non-state barrier is a very real one for reproductive rights activists to overcome, hopefully in cooperation with women who are doing work on gender violence. A lot of the panels already have talked about what the International Human Right to Health is, its substantive content. I would just add and highlight that the clearest articulation and the most expansive one, to my mind, is the Cairo Declaration that perceives reproductive rights to be owned by women and demands that governments do something to guarantee that they can be realized. And certainly, to my mind, that would include greater protections for women and keeping them safe. So sexual violence can be seen to impede the bundle of substantive rights that the health right includes. A lot of the reproductive conversation talks about choice and the meaning of choice. And when we look at violence and how it impacts particular classes of women, the question has to be raised as whether there is a meaningful choice at all. Professor Davis has talked about family caps, and that's influencing women to choose not to have children. There's also, at the other hand, no federal funding, at least in the United States, for abortion for women who would be poor. The reality of women's lives lay at the intersection of violence. And those women who, particularly those who suffered discrimination in addition to their abuse, really are operating in a space where the state intersects with these non-state actors to make choices virtually meaningless. So I would suggest that the utility of talking about pro-choice and pro-life, particularly in the context of violence, is maybe less compelling than talking about general reproductive justice, particularly for women who are vulnerable to violence, which at varying levels is any one of us in this room, but particularly for those who are less likely to access the medical system, less likely to access, for various reasons, justice, or want to engage police in their intimate partner exchanges. So a lot of overlap in these areas, less intersection in a conscious way. So I'd like to turn finally to where the opportunities of overlap are in this area between reproductive rights movement, the violence against women movement, and reproductive decision making, making those truly realities and real choices in women's lives. The solutions lie in law, and we have laws prohibiting gender violence, and abortion is legal. But the problems not only are in the state, but in the non-state actors that are able to infringe. So the rights require remedies. So women who have these rights on paper need to have ability to have access to justice. So police training, more women in police forces, and more diversity. There's a very recent unfortunate case, Castle Rock, that seems to move us back from women having access to remedy against violent actors. This was a case where a woman had a restraining order against her husband, went to the police multiple times, and it is now, according to the court, within the police discretion to decide how it is they were going to respond. They didn't respond, and it was too late, and her children were killed. And again, laws are on the books, but the distance between the popular culture, the social culture, and women's economic dependence on men who are sometimes violent isn't really answered without going further. So women need access to justice. They also need access to care, particularly women of color, poor women, and a rights approach needs to be taken in clinical management. Women seek treatment later or maybe not at all because of past engagements with the medical profession that have been less than respectful. So how do we get to these places? I spend a lot of time talking about gender violence to other women, and I'd increasingly like to talk about gender violence to men, because I think it'd be essential to have allies in this, in early intervention. The gender role idea formation is formed very, very early. Studies, again done by WHO and others, indicate that attitudes about gender start early and they have implications for adult behavior. So what if we were to approach the Boy Scouts and say, look, this is what gender violence is. These are gender roles that are confining not only to girls but to boys, and engage the conversation in the cultural sphere. I mean, I'd love to see a Super Bowl one year where the halftime show talks about gender violence or choice. It's unlikely because we have the Swiss bikini team, whatever. But I really would encourage academics and advocates to think more creatively about forging alliance strategies with allies outside the space of law. And that's the kind of conversation that's happening between pro-choice and pro-life, not between them, but amongst them, right? I mean, those are socially mobilizing forces outside of the legal arena, but certainly culturally potent and powerful. And I would imagine one could be pro-life, but have very strong opinions about women's bodies and not being violated by rape or violence, which would decrease the number of unwanted, unplanned pregnancies and injurious, unsafe abortions in some contexts. So I'd like to end on an optimistic note that in the global public health arena, human rights and global public health are increasingly recognizing violence as a major public health crisis, and there can be space for conversation for talking increasingly more about how women's full lives and their health, including sexual and reproductive health, is compromised by violence, and what the broader implications of that are for society, for economic development, for children, and for women themselves. And women NGO activists are leading a charge in this area, but I would invite others along to join and find new ways of strategizing and allying with those with previously whom we may have different opinions or stand against. So to turn to remedy, I think a focus can be on prevention and including people in positions to do something about violence. Those with power to prevent violence are men. Not all men are violent, obviously, but most violent assailants against women are men. So a conversation that considers why that is and how that can be changed early on can be promoted by the state through public education, through education of people involved in the justice system and in the medical system, and I'd invite academics to engage in that as well.
I'm going to be the last in the course of thank yous for including me in this symposium. And I also want to thank my brilliant students for inviting me. I really have benefited so much from the interns like Sarah and like Nadja that we are lucky to have at Human Rights Watch all the time. So thank you. I'm going to build a little bit on what Erika talked about, to step a little bit even further from the reproductive rights conversations we've had till now, to talk about state and non-state efforts to control sexuality. And then I'm going to talk specifically about some of Human Rights Watch work on this issue, and then move back a little bit to talk about a right to health framework, both as it's developed a little bit within Human Rights Watch, and I'll invite Erika to comment on this because she was there at the beginnings of this difficult process, and also about the right to health more broadly as a tool. So in many countries around the world, we know that government efforts to control non-normative sexuality, and by this I mean non-marital, non-reproductive, homosexual sex, for example, non-procreative sex, sex outside of marriage, I think I already said that, result in serious human rights abuses. And these abuses are really wide and varied and include police torture and ill treatment, arbitrary detention, denial of essential medicines and basic health services, and information about them, just to name some. Now, in our work at Human Rights Watch, we've reported on a wide range of such abuses, including in cases in which police join in violence against men who are perceived to be homosexual, and against individuals engaged in sex work, routinely refuse to accept complaints of serious violence or abuse, or to adequately investigate or prosecute them. We've documented government physicians who conduct forcible anal exams of men suspected of engaging in homosexual activity, citing as their guidebooks outdated 19th century medical manuals. Also forcible vaginal exams to assess virginity, in cases in which girls have acted outside of their gender norms and are in some cases incarcerated when their virginity has been challenged. My first work at Human Rights Watch was about government officials' censorship of life-saving information about HIV prevention and contraception. It was in fact some of the most controversial work that I've done, and it was in Texas. And I can go on. Now, in my brief remarks here, what I want to focus on is one aspect of these abuses based on work we've been doing with Jamaican colleagues since 2004. And I want to use this example to explore the role of human rights advocacy on the ground. And for students here, I guess, it's always helpful for me to remember that there's no formula for doing this work. And also, just for the purpose of this presentation, this is very partial in terms of what we do. Just first briefly a note about Human Rights Watch, which is the organization that I work with. Human Rights Watch monitors human rights developments throughout the world and puts out more than 100 reports a year on some 80 countries. We started an HIV/AIDS and human rights program in 2001, long after many others had been framing HIV as a human rights issue and advocating for a human rights-based response. At Human Rights Watch, we've issued at least 40 reports, hundreds of policy recommendations, and dozens of policy papers on countries as diverse as the United States, Canada, the Dominican Republic, India, Bangladesh, South Africa, Thailand, China, Kenya, the Philippines. The list goes on. And our research and advocacy is based on first-hand testimonies of people living with and affected by HIV and whose marginalized status puts them at the risk of the disease, and exposes the terrifying range of abuses that drive the epidemic, and we hope compels governments to act on these abuses as part of an effective AIDS response. So to take a step back, why did we go to Jamaica? just briefly, the Caribbean is the region second most affected by HIV and AIDS after sub-Saharan Africa. Jamaica has one of the largest populations of people living with HIV/AIDS in the Caribbean, and its epidemic is significantly around the time went there was growing. In Jamaica, as in most of the Caribbean, most people get HIV through heterosexual sex. But despite this fact, myths about HIV persist. HIV is stigmatized as a disease of homosexuals and sex workers, and as Jamaica's Minister of Health and the head of its HIV/AIDS program have acknowledged, the incorrect but widespread perception that HIV/AIDS is a homosexual disease keeps those at highest risk of the disease, including people who don't engage in homosexual sex, like married women, from taking measures to protect themselves because they believe that they're not vulnerable to HIV. So back in early 2004, we began to hear numerous reports of human rights abuses against gay men, sex workers, and AIDS outreach workers working with them, and against people living with HIV and AIDS in Jamaica. And we contacted local groups and human rights activists in Jamaica who confirmed these reports. And they told us, and they showed us, that they had been documenting these abuses themselves for some time. In fact, some of this information had been presented in government testimony, in memos to the government, in peer-reviewed and published in peer-reviewed journals. But after discussions with these groups, we were invited to and decided to investigate the situation for ourselves. We are often asked what we have to bring to the table. These groups know the situation. The groups in Jamaica are fairly sophisticated. There's a vibrant democracy. There's a very active public debate on most any human rights issue in Jamaica. So what do we have to offer? First of all, the one gay and lesbian group and the HIV/AIDS groups invited us to work as their partners in this effort, in hopes that our joint work could raise the profile of these issues as human rights issues, of sexual orientation and gender identity discrimination, of HIV/AIDS-related discrimination as human rights issues, not just public health problems or not just personal problems, between jilted lovers, which is how gay issues are often characterized. And they thought that if we could do this, we could help hold the government account and work with them to address these problems. Building the understanding of these human rights issues would strengthen not just domestic efforts to address them, but also international efforts. The other thing is that Human Rights Watch is a mainstream human rights group, and so we were able to help build a coalition of mainstream groups working on these issues. It's often the case, I don't work with the Women's Rights Division, but one experience we have in common with the Women's Rights Division, those of us who work on children's rights, HIV, health, criminalized populations, whatever, often the things we work on are not considered human rights issues by mainstream groups. And so they don't work on these issues on a local level, but also they don't see them as issues, and they don't see themselves as having issues in common with these groups. And so when we went to Jamaica, all the mainstream groups agreed to meet with me. They said, sure, we don't work on these issues, but we're happy to meet with you. But through the course of the 3 weeks that I was doing this research, one of the things that they came to realize through their first-hand experience with myself and the people, my colleagues, was that what we were doing, to a large part, was documenting police violence and impunity, the bread and butter of their work, and they have been our partners since. Now, lastly, but actually most importantly, one of the things that Human Rights Watch brings to the table is the participation of the people who are affected by these abuses. So in the case of people who are stigmatized, marginalized, and often criminalized, and in this case it was gay men and lesbians and transgender people, as well as people living with HIV and AIDS, they can't appear publicly safely, especially in a country as small as Jamaica. And so this was one way, publishing a report documenting, using their words, is one way to bring their issues to the fore. There are also other ways in which we can and do that, but just in brief. So what did we do? We interviewed more than 75 ordinary Jamaicans, including at least 22 people living with HIV and AIDS and 31 gay men and lesbians, and talked with them about their experiences. Through these interviews, we found widespread violence and discrimination against gay men and people living with HIV/AIDS, and that we found that even despite this the government statistics and well known that HIV/AIDS was spread predominantly among people who engaged in heterosexual sex, the abuses against gay men and lesbians were undermining an effective response to the epidemic in several ways, which I'll elaborate on in a minute. And we also found separately a disturbing pattern of abuse of people living with HIV and AIDS. So just two specifically horrible examples. Just to step back to this abuse was not just state-sponsored, it was also by private individuals. So during the time I was in Jamaica, I spoke to a number of men who had been brutally beaten by the police and some who had witnessed murder. I spoke with men and women who faced verbal and physical abuse ranging from beating to armed attacks to murder when they walked down the street simply because of who they were or who people thought that they were. And I spoke with many people, men in particular, who when they faced abuse, they had no one to defend them. They couldn't go to the police because the police were often among the abusers. They couldn't go to the general public because no one wants to raise their voice on behalf of someone who is gay in Jamaica, and often their own families threw them out of their house and their communities, and sometimes threatened to kill them when they found out that they were gay. So when I was in Montego Bay in June of 2004, I spoke with several men who told me that just a few days earlier, they had witnessed police join in a small crowd abusing a man on the beach because they believed he was a homosexual. First, the police beat the man with batons and then urged others to do so. One witness told me that he saw police officers beating the man and asked one of them what the man had done wrong, and the officer said, "Every day I have to go warn this guy coming down the beach. I'm going to lock him up." So the witness asked for what, and the two police who were there just said, beat him because he's gay. And so after exacerbating the violence, this man, the police eventually left, and then the crowd beating the man grew larger and the man fled. And I'm quoting a newspaper report now. The mob chased the man and chopped, stabbed, and stoned him to death. The following week, I met with several men who told me that they had been attacked by a dozen men armed with machetes, guns, and knives. The attackers had forced their way into their home and beaten them up while denouncing them as homosexuals. When I went to the police station with the victims to report this incident, we saw firsthand how difficult it was for gay victims of violence to get the police simply to listen to what they had to say. Several of the police just laughed when the men reported what had happened to them and made fun of the victims. They made fun of gay men. It took the combined efforts of all of the major human rights groups in Jamaica, Jamaicans for Justice, the Independent Jamaican Council for Human Rights, Families Against State Terrorism, as well as others, to make sure that the police would even take the men's statements that night. And just as an aside, it took 4 hours, at some point I was also threatened with arrest for trying to get a copy of the statements. And again, what Human Rights Watch documents, we're not litigating these cases. We are documenting a pattern of abuse and asking the government to intervene and take action. So I mentioned earlier that one way that discrimination and violence spreads HIV in Jamaica is by driving people who are in need of help and information away from HIV prevention and treatment services. So gay men told me that health workers had refused to treat them at all, made abusive comments to them, and disclosed their sexual orientation, which put them at risk of homophobic violence by others. As a result, many gay men said that they later avoided seeking health care altogether, especially for health problems that they feared would mark them as homosexual, like sexually transmitted diseases. And since the presence of other sexually transmitted diseases heightens the risk of HIV transmission, this means that such discrimination can have fatal consequences. As I said before, another way that homophobic discrimination spreads AIDS is, as the Ministry of AIDS has acknowledged, that the association of HIV with homosexuality, coupled with the deep stigma associated with HIV, drives people away from, well, keeps people from taking necessary precautions to avoid it and from seeking testing or treatment. We also documented, as I said, a lot of violence and discrimination against people living with HIV and AIDS in healthcare as well as in public transportation and the like. And I commend you to look at the report online if you'd like to know more about it. I want to talk a little bit about our advocacy with the report. Now, we released the report at a press conference in November of 2004, and the 5 Jamaican human rights organizations supported the launch of this report. This was unprecedented for people for 3 of them especially to speak publicly about HIV or about any gay rights issues. Now, for this courageous act, they were accused by a representative of the Jamaica Police Federation of joining Human Rights Watch, and I quote, from a letter that he published in the paper, to spread lies and deliberately malign and slander the police force and the government. And so in this letter that was published in the Jamaica Observer, the Federation went beyond just defaming the advocates in Human Rights Watch. It also called for their arrest, and it demanded that the government slap on sedition charges where necessary to both foreign and local agents of provocation. Now, I talked earlier about participation and its importance, and I'm going to talk about some of the challenges of participation. It was hard enough to get the mainstream human rights groups to join any of these efforts, but I think what galvanized them it was their assistance in helping file these complaints. And then when they were so insulted publicly by the police that they didn't even know how to do human rights work and weren't doing anything valid, that further galvanized their support. And as I said, they've been partners since. But the participation of the people affected is, of course, a critical human rights principle and is extremely difficult when people face this kind of violence. Now, the report has a picture on the cover of someone who faced violence. My colleagues know who this person is. He couldn't appear with his picture on the cover. The gay and lesbian group issued a statement at the press conference, but they could not appear in public. And so violence has consequences beyond what Erika talked about. It leads to invisibility. And what it means is that it makes it easier for the government officials to deny the violence and for ordinary people to ignore it. And it pretty much undermines people's basic ability to participate as full citizens. And I just want to give you one particularly chilling example. A few days after I'd arrived in Jamaica, Brian Williamson, who was the country's leading gay rights activist, was murdered in his home in a middle-class neighborhood in Jamaica. He was the public face of gay rights in the country and the only person willing to go before the cameras or sign his name to letters to press advocacy on gay rights in Jamaica. A few months later, Steve Harvey, an outreach worker for the Jamaica AIDS Support, who helped me with the research on this report, told the UK Guardian that Brian's death was a real blow. He said, "It hit home on a personal level because he was a close friend to all of us. But it hit home on a political level, too, because he was such a crucial part of the community." A few months later, on November 30th, on the eve of World AIDS Day, Steve was abducted and murdered, and eyewitnesses reported that the gunmen forced themselves into their house, asked Harvey and his flatmates if they were gay. He didn't answer. The flatmates also reported that there was a picture of Steve and his lover on his computer. They saw it. He was taken away and he was killed. So in this kind of environment, what can we do at Human Rights Watch to foster participation? As I said, one way is to try to include the voices of the people in a safe way. So we use pseudonyms in the report, including for a prominent member of the bar who represented some of these cases. We make sure, as much as possible, that they take the lead in the advocacy efforts. That means sometimes we don't do things. I think the most obvious example is there's a few advocates in the UK and the US have tried to have issued a call for a boycott of tourism in Jamaica. Tourism is where you could get, it's one place where you can hit them where it would hurt. The LGBT group on the ground and activists in Jamaica have cautioned against that. They said, look, we will get enormous backlash if that happens, so please don't do it. So that's one place in which, just one small example. We've also worked with Amnesty, for example, and other groups to foster opportunities for people to come outside of Jamaica and to speak to important decision makers. So after the report came out, the two co-chairs of the gay and lesbian group came to DC, and Amnesty arranged an appointment with them to meet with the State Department. The State Department every year puts out a human rights report, and they were able to report, to include this document, but also give their own report to the Human Rights report. Their issues have, and we've been working with them to file updates every year. Their issues have been included in the US and the UK human rights, the Home Office human rights reports every year. These things are important because this is basically the desk manual for immigration officers who are deciding asylum or torture claims. Just really quickly, you know, the regional and international monitors have gone. The Inter-American Commission has done an investigation. The Special Rapporteur on Torture is going next month. Now, my time is really brief, so I just want to move to the last point about using the right to health as a framework. First of all, when I first started working at Human Rights Watch in 2002, it was revolutionary to make a right to health claim that was separate from a civil and political rights claim. And through the work of my colleagues, we now have reports that are straightforward right to health reports and aren't tied to civil and political rights claims. But it's also made us stand back and reflect and talk about strategically when that's a good idea and when it's not. So, for example, when Erika was talking about abuses that take place in healthcare settings, they're often understood narrowly in the human rights community or in the medical community as violations of the right to health. But in many cases, they're actually violations of the right to be free from torture and ill treatment. And that opens up a whole other body of advocacy which isn't discretionary, which isn't subject to availability of resources, and brings a whole different level of responsibility on the state. And so some of our reports where we have documented serious health rights violations, we've actually only discussed the torture and ill treatment violations because that brings an immediate claim in that the other ones don't. That I'm going to end with that point because my time is up, but thank you.
All right. Thank you to all of the speakers. We have about 20 minutes for questions. And we have microphones going around.
Hi. I have a question for Rebecca, just following up on that. You mentioned that you were just recently, they've been filing the right to health claims as a claim separate and apart from the civil and political. Is that against whom? Is it against...
Maybe I misspoke. And what I was saying is that in many of the cases that we've documented, we can claim abuses of the right to health, as well as abuses of the right to be free from torture and ill treatment. And that sometimes strategically, it's best to just appeal to protections against torture and ill treatment and not to rely on the right to health, because it brings in actors that have to act immediately. And sometimes talking about, for example, just to give you we've been doing a lot of work on human rights abuses against people who are mandated to drug detention in several countries in Southeast Asia. In these centers, many of the people who inject drugs have HIV, have hepatitis, face all kinds of they need all kinds of health care. But our position on these centers is that you should shut them down. And there's a debate among some activists and with the UNODC and UNAIDS about should we, improving the health conditions in these centers. And our position is people are being tortured in these centers. They include children, they include women, and they should be shut down. So, that's one stark example. I think another example would be with respect to reproductive rights issues. In Nicaragua, where doctors are constrained to deny life-saving abortions to women because of the law. I think that's another place where you can bring in arguments at least of cruel, unusual, and degrading treatment.
Why do you think governments are just so unresponsive to work with agencies on these types of claims?
Which particular claims? Human
rights issues that are not specifically targeted against a government.
Human rights abuses by non-state actors?
Right.
I think that's a big question. I think I would give some of that to Erika. I think it really, in some cases, police don't want to do their job. I think with the domestic violence claims, that's a particular case in which police can, often these things are considered private matters. I think one of the ways police get out of doing their job, and I think in the Jamaica case we were told this by many police, is that they say, look, this was a lover's quarrel. It's not our business to deal with lovers' quarrels. So by first of all minimizing, just denying the fact that there's strong evidence that there was nothing about love to do with particular murder or an incident of violence, that's one part of it. And two, police do have obligations with respect to private violence in many countries, under international laws, but also under domestic laws, and they just don't want to do them, and that happens in the US as well as elsewhere. Do you want to answer?
Not much more to add than that, but police are coming from the societies in which they are, right? So it may be that your perception of what's actually going on between the intimate partners is none of your business. And they're harder calls to respond to if you're police. And often it is something you're responding to over and over and over again. A lot of women don't leave a batterer the first time they leave. They go back, and then they go forth and back and forth and back and forth. So it's not uncomplicated, but I think you could achieve greater clarity with more training and taking very seriously these obligations rather than giving this space of discretion without guidance, which is where we are kind of now in the U.S.
And I think there's another place where police do not take these, we found in our work in pretty much any country where we've done this work, is that there are people who are not considered, there are people who aren't considered to be able to say no to sex ever. So when a sex workers try to make claims of rape to police, police laugh, and they say things like, oh, you're just pissed off because you didn't get paid. So we have documented that kind of, and so that's another example. And I think the other thing with respect to police, and I don't know, I mean, I can tell you this with respect to my work on drugs issues, is that there are structural reasons which lead police to do things that are abusive, and there are structural responses to some of those abuses. And so just as an example, in many countries have quotas, either formal or informal, for arrests, and police get promoted based on the number of arrests they do. And there's no quality control. It's a quantity measure, not a quality measure. And so we have been told, in the UN Committee Against Torture, for example, has discussed this in several cases, that the pressure to arrest people, basically what happens is that police pick off easy targets. And so, because they need to meet their arrest quota. And so people have started talking about, in the UK, for example, about different incentives to get police to do their job. So could maybe, with respect to drug users, could they refer more of them to housing? Maybe if you could get the same kind of credit there as you could get for arresting low-level drug users, then that would change the incentive structure and lead to less abusive policing.
I think we had a question right here.
Yeah. I want to thank all the panelists. There are actually so many interesting things, but I have just two questions that I want to pose. The first was, Martha, I thought your presentation talking about the line between, a nudge and a coercion was very interesting, and I think it was great that you were looking at instances where women are actually being restricted or perhaps coerced in terms of their choice to bear children. But I think you could also look at, in the context of abortion jurisprudence, right, this view since Carhart that the government has a right to place its finger on the scale of decision making and look at laws that require women to actually view ultrasounds and have them described to them, and think about how that's punitive in terms of coercing women to have coercing women's decisions. And Eric, I thought that it was interesting. I thought it was great that you were drawing attention to violence against abortion providers and the link in terms of the violence and the fact that a lot of that violence really is trying to undermine women's access to reproductive health care. And I think that's really important. In the center, we actually did a report also looking at attacks on reproductive health providers as attacks on human rights defenders. And I think that's another way of sort of looking at a right to health issue from a civil and political rights lens. And I don't know whether you thought about that, those kinds of arguments.
No, I'll have to look at the report. That's great. Yeah, it is interesting because in the real world, the doctor has a right to practice and have this relationship with his patient, and they aren't often talked about, and I think there's a lot of silence around the violence against them, and it's in the persistent kind of aggressive harassment that seems to ebb and flow, but it's on the upswing right now, so it is cause for concern. And I'm not an exclusivist about how to protect reproductive rights. I actually had a question for you about this. But I mean, I think that reproductive rights, it's both negative and positive. It's both socioeconomic and civil and political. I think of it as a bundle of rights, and there are multiple duty bearers involved in the process, as well as rights holders. And the physician occupies kind of that dual space to my mind. So yeah, it's something I should think further about.
Yeah, I'll just say, in response to Cindy's comment, that you're right. It's very complicated to identify where the state is behaving appropriately neutrally with respect to enforcement of negative, or with respect to its responsibility to not interfere, as opposed to doing something proactive, and that the line gets muddier and muddier in the abortion context, where now under an undue burden standard, it's with states developing sort of proactive measures that are intended to test that standard. To what extent do you look at it through an unconstitutional conditions lens, or through the undue burden standard, and so on. So I agree that it's very complicated, and I was I guess in thinking about this myself, I was trying to look specifically at the instances where the state is involved in the area already, and that involvement is accepted, as opposed to areas like abortion, where the state has increasingly, maybe in response to political pressures, become more proactive, and where the area is shifting. So in the welfare context, we can say for 60 years the feds have been providing welfare. That's an accepted area of activity, whereas in the area of ultrasound, or sort of proactive kind of interference with reproductive rights, maybe that's a sort of a more recent development to some extent. So, but I agree, it's a complicated area.
Mental illness can be such a big component in all these kinds of issues. Is there any opportunity to sort these out and determine which ones can be treated and all that kind of thing? We have all that problem here in this country and in all these other countries. It just seems like such a big issue. Schizophrenia as violence, and all of these issues, that all comes into this. And there's high percentages in all these countries. Maybe they just get lost in all this. I don't know that. That's my question. 1% of schizophrenia is 1% of the population. That's a high number when it comes to the kinds of issues you're speaking about. Do you deal with, can you sort that out at all, or is it just lumped in with everything else?
In my office, we just actually hired a designated disabilities researcher as part of our larger effort to do more work on this issue. But we've done, Human Rights Watch has done some work on mental illness in U.S. prisons, because, that's one dumping ground for people with mental illness. And there is ongoing work on mental illness and women in places of detention. I think the other place where there's a lot of work for human rights workers to do, or human rights experts to do, is that there are international principles of involuntary treatment of people with mental illness, but that's as far as it goes. And so one of the things that we've been pushing and a related level is what it is for international standards on involuntary commitment of people for drug treatment, which is which overlaps sadly with the treatment of people with mental illness.
Anyone over here? Okay, in the back.
So, Professor George, you made reference to the case in Wichita of the murder of the physician that ran the abortion clinic.
Yeah.
And that case, as I understand, is going to trial. And the court apparently is accepting the use of a defense that it should really be a manslaughter, or that to reduce it from a murder charge to a manslaughter charge, because of a sincerely held belief that it was necessary to save a life. Which it seems to me that if that's indeed the case, then any time somebody would murder a physician over this issue, it's not murder. So I guess I'm wondering, do you see that as an example of state support for violence, if that is accepted? How would you argue against that defense, or would you argue against that defense?
I would be deeply troubled by that defense, because it kind of by omission expresses open season on physicians. It's problematic. I think you know that. That's why you posed the question. Yeah, I wasn't aware that that had been one of the defenses introduced. And I don't know what the AMA has been doing or what medical societies have been saying or doing around this issue. But, there are people who object to contraceptives as well, right? So it would take things down a rather slippery slope. This is not to deny that people have very firmly held political beliefs, but we don't reward implementation of those beliefs or giving manifestation and effect to those beliefs through violence. So I would be deeply concerned about how that proceeds through the court.
Can you argue against?
Well, the alleged facts are that this was a premeditated occurrence, and it would seem to me something that I'm not a criminal lawyer, but manslaughter seems an inappropriate level by which to regard this.
I think we have time for one more.
I'm wondering if in all of these issues, whether it's over in the Arabic countries, whether it's in the Italian, whether it's down in the Caribbean, are we ignoring what I think of as sort of the umbrella of the elephant in the room? Is religion really playing a very high role in this? And should this be one of the areas that we should be trying to work with to be able to separate religion and the state's function? And how can we go about doing this? And am I just misperceiving this, or do you all see this as a topic?
Who wants to go first?
Portray it to all four.
I'll say something.
I mean, you're spot on. I mean, I think that religion plays an important role. And, the Vatican, the Holy See, has a place at the table at the UN. They play a really important role in international politics. They not only comment on issues of reproductive health, they also said that harm reduction, efforts to reduce the harm of drug use, is anti-life. And so, but by the same token, I think religious leaders can also be important partners. And I think both in terms of the individuals who are affected by abusive policies, as well as in a political sense. And I'll just give you one Jamaica example really briefly. When Steve was killed, the New York Times wrote an editorial about it. And I got a phone call from the Metropolitan Community Church, which is a LGBT, lesbian, gay, bisexual, transgender church based in Florida, and they said, "What can we do?" And I said, "I don't know. Why don't you go and talk to people in Jamaica?" One of the things that people had told me in Jamaica, LGBT people that I spoke with, which I've interviewed probably thousands of people now all over the world about various issues, and religion is an important thing to many people throughout the world. But one thing that I'd heard in Jamaica that I hadn't heard so consistently was, when I asked about the serious harms that they suffered, people said, "I can't go to church, so I visit." And what that meant was they couldn't go to their home church, and they would go from place to place if they felt comfortable. And so what MCC did is they went and they talked to people. I told them this story, and they founded a church. So there is something called the Sunshine Cathedral. It meets once a month in Kingston and 3 other times a month in other parts of the country. Of course, it meets in secret, and it moves. But it is a source of important spiritual support for people. They've also tried to engage the support of other actors. Now, I can tell you that their efforts in Jamaica are difficult, but they have partners outside of Jamaica, so that is an important part of it. I think the other thing, though, is that people often blame culture or religion on things that political leaders are doing. And so in in Jamaica in the 2001 elections, both political parties used songs in their campaigns about killing gay men. So this comes from the highest level of government. This past year, they called for the increasing penalties on homosexual sex to life in prison. The prime minister said, "I'll never have a homosexual in my cabinet." So religion plays a role, but high-level political leaders do too. So.
I'm thinking in great deal, having just come back from the Middle East, of what's going on in the Middle East and in the African countries when you're dealing with Muslim religion also. So it isn't just the Catholic religion, it's all.
Well, and I also think you need to pay attention to what's going on in Uganda. I mean, it's U.S. Christian leaders who went over to Uganda who gave talks that fed into the pretty violent anti-gay rhetoric that is now inscribed in legislation that is, that's likely to pass. So,
Oh, I was just going to add, though I think some of those same religious leaders are now horrified by the death penalty for being LGBT. Okay, maybe not horrified. You're looking at me like I'm. I just wanted to add that.
For years, though. I mean, these guys have been working over there for years, so I think it's disingenuous, but.
Okay. Well, but I think maybe some of them didn't fully appreciate the consequences of their actions. I mean, I think a lot of people, frankly, play with religion for political purposes. Mm-hmm. So if you look at the swings back and forth in violence and that they really closely correlate with transfers of administrative power between the rebel, it's a bit of an elephant in the room. That said, religion is not monolithic. There's a very organized group, Catholics for a Free Choice. And what I think there needs to be is more voices of pluralism within the religious community within the United States. And I do think that religions can be active partners in promoting human rights. Again, to take the Catholic example, they're wonderful in doing tremendous work with refugees and resettlement and anti-death penalties. So I think that there can be opportunities for maybe cafeteria coalitions around certain issues, and I think violence could be one of them. But there does need to be a more nuanced conversation about religion that is difficult to achieve, at least in public discourse, but certainly in these kinds of spaces, there should be the room.
I'll just add one more thing. I mean, I think you referred to as the elephant in the room, but in a way, I guess, and maybe this is playing off what Reva said during after lunch, is that one of the reasons to look to human rights as a way of discussing this is because that engages with values very directly in a way that a more secular, I mean, human rights is secular, but in a way that our domestic law doesn't, that it uses some of the language of religion, and so it actually is a basis for having a dialogue in a way that, relying on domestic legal frameworks might not provide that basis.
One last question from Dean, and then.
Just to try to wrap up the last couple of comments, I mean, religion plays a role on both sides, and Professor George mentioned some people are hostile to contraception as well, and there has been a move, at least in some places in this country, to try to allow healthcare professionals to receive some kind of conscientious objection from providing reproductive health services that they find morally objectionable. And I guess I realize that we are at the very end of the day, and this is a big question in some sense, but where do we put that in this discussion about religion, human rights, and autonomy?
So there was an interesting decision by the Colombian Constitutional Court on that issue recently, excuse me, where in that instance it was an individual judge who refused to rule in a case where he would have been required to permit somebody to get an abortion. And what the court said was that individuals with proper documentation could use some kind of conscience clause, but that the state still had an obligation to make sure that that access was available to contraception or abortion or whatever, and so that the onus was on the state, and that the individual also maybe had to make sure that there were alternatives available, that they couldn't be the last resort and say no. So there may be something, and that was a court that, as in the earlier decision where they liberalized the abortion law generally, where they were referencing human rights norms as a basis for reaching that conclusion. So it's something that I think we can learn from domestically.
Yeah, and I think it also, again, raises these questions about what, if there is a right to health care, what kind of right is it, right? Is it narrow? Is it broad? And, these questions about whether something is a health care, is a medical intervention and so on, are often do come up in precisely those cases, and whether it was a necessary intervention and so on. So, again, it would be helpful to have a particular working definition to answer that question.
Okay, I'm supposed to remind everyone that there is a reception at Black Acre now. The lower rotunda. Right there.